I'm with Natalie Fielding today, and she is a principal lawyer at Macpherson Kelley. She specialises in family law. Welcome, Nat.
Thank you very much.
No problems. Nice to chat to you. We did have a bit of a chat earlier on about most of these topics, and they're very, very important topics, not only in the general scheme of things, but for our clients in Fidget, being mortgage brokers. The topics that we wanted to talk about, and that's why we've got the pro, is to do with family law. And my clients come to me usually at the end, like when there is a breakup or an impending breakup in a relationship, and about what to do with property. But I thought maybe we just start off by, if you can just tell me a little bit about family law from a family lawyer standpoint, like when do people need or should they engage someone like yourself?
Yeah, absolutely. I think, Lee, that I describe my job that I help people start and end their relationships and everything in between. So someone should come and speak to a family lawyer if they're entering into a new relationship, or they're taking their relationship to the next level. So they're wanting to protect their assets. They can enter into what's called a binding financial agreement, which, as the name says, is a financial agreement between the parties that determines what's going to happen in the event they're to separate. The other aspect of family law is after people have separated and they're working out what's going to happen with their money and their children. Quite often we will see clients when they're in the process of working out if they're going to separate and what that might look like for them.
Okay, so we talk about separation, and so I'd like to think of it, and we spoke about this, I'd like to think about, entering a relationship, ending a relationship, because essentially family law is dealing with relationships, yeah?
Absolutely it is.
So if we talk about entering relationships, because I think that's probably a misconception we hear a lot, is that you only need to engage someone like yourself at the end, right?
Yes.
So if we say entering, you mentioned binding financial agreements.
Yes.
So if, say, one of our clients was to have an asset, for instance, an investment property or a family home or some other types of assets, and entering into a relationship, or they may have already entered into it.
Yes.
Is that what you mean by binding financial agreement?
Absolutely. So what happens with a binding financial agreement is it will determine what's going to happen in the event that these people are going to separate.
Okay.
So it can be talking about the assets they bring into the relationship. It can also talk about assets that they will accumulate during their relationship.
So a binding financial agreement is like a prenup, right?
That's correct. That's right.
Okay.
So in Australia, they're called a binding financial agreement or financial agreement. They can be entered into at any stage in your relationship. So at the start of the relationship, during the relationship, or at the end of the relationship. For them to become binding, people need to obtain independent legal advice. So they can't have the same lawyer. They both have to go to lawyers in separate law firms to provide them with advice. And the lawyer signs a certificate that's attached to the agreement stating that they've provided the person with advice.
Okay, so you mentioned relationships. It's probably I'm going to put words in your mouth. It'd be a misconception about what even a relationship is. Like, when does it start? Do you meet someone at the bar, or is Hugh Hefner in a relationship with all the bunnies? What is a relationship in the scheme of things? Like in Australian law, for instance, or when does it actually start?
So it starts, a married relationship starts when people get married and they sign the marriage certificate, and that's the commencement of their relationship. A de facto relationship is always a little bit ambiguous. Often it's when they start spending substantial amounts of time together and spending time overnight together. They might still have their own residences, but they're spending a substantial amount of nights together. That can constitute a de facto relationship. Also, people can be in multiple relationships at one time. So there are people who will be married to one person but have a de facto relationship with someone else. Sometimes people might have multiple de facto relationships. They can all expose them to a potential family law claim.
You were talking about going to a new relationship.
Yes.
But they have, I will call it baggage or something from previous, right? Previous marriage, previous relationship, because they lived with somebody. They may not have owned technically assets with them, but if they were to say pop back up later and say, hey, my ex is doing really well with new family,
Yeah.
but I want a piece of that, could that also protect them in that instance?
It can, but what they'll need to do is terminate the end of the financial relationship with the other person.
Okay.
So the ways in Australia that you do that is a consent order, which is an order made by the Federal Circuit and Family Court of Australia. People don't go to court to have a consent order made. It's made in their absence, but it's an actual court order with a court seal. Alternatively, there's what's called a binding financial agreement, which is a private agreement between the parties, and they both obtain their own legal advice, or you have a judge make a decision. They're the three legally binding ways to get a financial settlement in Australia.
Okay.
Unless you have one of those, your agreement's not worth the paper that it's written on.
Okay, cool. So we've covering off the entering relationship piece where people are, and I have clients come to me and say, I want to take out a home loan and I've got a new relationship. We haven't moved in together and maybe in the eyes of law they're not considered de facto just yet, but they might have assets. So they'll come to you and say, we want a binding financial agreement to protect that, to make it clear for both people in the relationship that when we move in together or deemed as spousal de facto, that it protects the assets from previous, right?
Yes.
So then fast forward. So do people come to you when they're in the middle of all of this? Because we speak about start and end. Yeah,
it varies on the situation. Sometimes people will come to us when they're contemplating getting married or contemplating moving in with somebody. Other times they will already be in that situation and they're looking at, oh, hang on a moment, I need to protect my future inheritance and my parents want to protect their money, or their children, it's an older person and they've got adult children and they want to protect their inheritance, but their parent is entering into another relationship.
So you talk about protecting, you mentioned parents, right? So another thing we get a fair bit is a parent will support their child, and it's even more common these days. So the parent will offer up either a security guarantee on their home or they will offer, say, a gift, so a cash gift to help their child get on the property ladder.
Yes.
And if that was to happen, the parents, I assume here as well, would want to be sure that new relationship, new flame doesn't actually therefore take an asset which they otherwise contributed to this purchase.
Yes.
So could the parents in that instance, say, approach someone like you, or would it be...
Oh, that happens a lot. Okay. We often have parents that will make that a stipulation of providing the money to their child, that they enter into a financial agreement, so that's going to protect their family's money. So a binding financial agreement is one way of being able to do that. You can create loan agreements between the child and the parent in them giving money. They can establish it through a mortgage, or through a caveat that they could secure to notice to the world that they've got an interest in this property.
Okay, awesome.
And that's the best way to protect family money when it's been given to a party. Often people will be given a gift by their family, but unless it's well documented, in the event that they go to separate, it's not going to be paid out as a loan. If it's just, it will be simply treated as a gift. So if you want the money to be repaid, you need to have a formalised loan agreement in place.
Okay.
An ideal security for it.
From a loan standpoint, we have... So we have the lender will request a gift letter, for instance, that it's unconditional gift, and the parents may say there is no conditions. Having said that, the condition may be that at some point in the future you'll repay it if some XYZ happened, but there's no actual terms of per month repayments, right? So it's probably important to know that, lenders will request a letter that's saying unconditional gift, or what are the payment terms, because we need to factor that in.
Yeah.
So de facto, married, single, like spousal, what's the difference between all of these terms?
Yeah, so a married couple obviously are people who are legally married and that their relationship is under law in Australia. Domestic relationships or de facto relationships, they're people who live together but they're not legally married.
Got it. And spouse, like, is that another terminology?
And a spouse is, people will refer to their spouse as either someone they're in a de facto relationship with or they're in a married relationship with. Sometimes people call them their partner. They'll call them their husband and wife. Really depends.
Got it.
In regards to a de facto relationship in Australia, it's generally people who have lived together for 2 years or more.
Yep.
However, you could have separate houses. So people sometimes will have separate houses, but they'll come together and stay together on a regular basis, and that could potentially cause a de facto relationship under law. In Australia, the law was amended quite a few years ago, and so it actually means that whether you're in a de facto relationship or a married relationship, your relationship status is treated the same under family law. So if you were to separate, it wouldn't matter if you're in a de facto relationship or a married relationship. The family court is the appropriate court to deal with your separation, and they will determine what a suitable outcome is.
The lenders will actually ask, what is your living status? Like, what is your marital status, right?
Yeah.
They'll say, are you single? Are you married? Are you de facto? And that's pretty much the questions I would ask. And lenders don't really have a specific about the word de facto. They will say, if you're a de facto, then you're a de facto, and your living expenses are usually higher than they would be if they're single, right?
Yes.
So they use a thing called the household expenditure measure, or HEM,
Yes.
and there is a minimum amount per month that someone would be spending based on their income if they were single, married, or de facto. And as a broker, you kind of have to navigate that and say, well, they just moved in together. They don't have any kids.
Yes.
They met last Wednesday. Are they now a de facto? And you have to make that kind of judgment.
Yeah, so one of the things that we find that people often are really confused about when they come to see us is they've maintained separate finances throughout their relationship. One of the parties, they may have bank accounts and they've been a person who's spent a lot of money. The other person might be a really good saver, and they therefore expect they're going to take out what they're responsible for in regards to their assets. However, what the law says is that the assets all accumulated together and you have a combined asset pool. It doesn't look at what does one person have and what the other person has. One thing that does need to be factored into account is that they can look at wastage. Wastage could be anything from someone's gambling habit to spending money on alcohol or drugs excessively, or even excessive expenditure. And adjustments can be made to the outcome of a property settlement.
I guess we talk about relationships ending. Everyone's just split and we'll just shake hands and move on.
Yes.
But quite often, is it that these are pretty messy in the first place, and one party would say, you know what, I've been taken advantage of for so many years, or vice versa, or they haven't pulled their weight, and or they do have, say, a gambling or a drinking problem or something to that effect, or financial abuse is a real thing, right? So whereby they feel like they have had a separate bank account on the side all this time collecting money, because I have heard that before, where someone's had this slush fund, if you like, and they've had that separated because they think that that's now protected.
Yes.
Not the case, huh?
Not the case at all. It goes in together. And so people have an obligation to provide full and frank disclosure of their finances when they separate. And so what that means is that they'll have to provide details of all their bank accounts. They'll have to provide their superannuation statements, interests that they own in companies, interests they own in properties or shares or whatever their asset position is.
What if they don't?
What if they don't do it? So if they fail to do it, and you're at a court scenario, and the court finds that someone's failed to disclose assets, they can treat the situation and give an adjustment to the person on the other side because someone's failed to provide adequate financial disclosure. So that ultimately could result in them receiving a higher amount of the asset pool because the other person's failed to disclose their assets.
Okay, there you go. Quite often we have people who get a gift from their family member. It's very common at the moment with the cost prohibitive to get into a new purchase as a first home buyer especially. So mum, dad, brother, sister have gifted the purchaser some money as an unconditional gift potentially, and now they have let them go off and buy this property. So how is it that the parents in that example may be protected? Is it a thing that they could be protected later? Like if that relationship or a new relationship in a year or 2 or 10, someone comes in and now has claim to this property, but the parents gifted them money. Is there actually a legal I don't know, a legal protection for the parents in that instance because they've already gifted the money?
Yeah, and unless the gift is constituted as a loan, so there's a loan agreement between the parties and the parent, ideally that the loan would be secured over the property, either in a form of a mortgage or of a caveat advising that there is a loan that exists. The court would treat it as a gift. One way around doing that is by having a binding financial agreement that determines what's going to happen in the event there's to separate, and that money, that gift could be repaid to the parents at that point in time, or whoever's lent the funds. If that doesn't exist and the parties don't have a loan secured, or alternatively don't have a binding financial agreement, what happens is it's looked as a contribution by the person who's received the gift. And so what happens, Lee, in a property settlement scenario, to work out a property settlement, you work out firstly, there's a 4-step test, and what that determines is firstly, what are the assets and liabilities of a relationship? The secondary part is what are the contributions by the parties? So what did they have at the start of the relationship? What assets did they have at the end of the relationship? What do they have at the time they do the settlement? Because sometimes the end of the relationship and the settlement can be substantial periods of time. Has one of the parties received a gift or inheritance during the relationship? What was that, and what was done with that throughout the relationship? You also look at things like, what are your financial contributions? So who earned more money? Did one person stay home and primarily look after the kids or be the homemaker? And what effects does that have onto the relationship?
So when it comes to gifts, say a parent or a guardian has gifted the person money towards the property purchase, how is it that they are able to be, should they be the ones getting a binding financial agreement with the child or a loan, or is it more so that the child is the one that gets the agreement?
Yeah, it's a good question. It's the actual child and their partner would be the people that have the binding financial agreement that would be put in place.
So mum and dad gift the money, they could then request the child, if in the event you were to get in a relationship, I will request that you do a binding financial agreement to protect that gift that we gave you.
That's correct.
Okay, excellent.
Absolutely. And if they don't have that in place, what would happen is it would be looked at as a contribution from that child. But the longer a relationship takes place, the less value the gift has. So if you are to be given a gift and you separate quite quickly, you might be able to get the majority of that gift back. But if it's, say, in 20 years' time, depending on what the value of the gift was, it diminishes in value over a period of time. So, Lee, in the news, I've been hearing that the government is making contributions to people to purchase new property. How does it work for someone who is separated?
And they got a child?
Yes, they do.
Okay, all right. Yeah, so the government is actually providing as little as a 2% deposit for single parents or legal guardians of one or more children. So let's say in your example, you have somebody come to you that's now separating or separated and they have a child. They could then put down as 2% on the property as deposit plus stamp duty. The short answer is that if they're a single parent or legal guardian of a child, the government has provided a 2% deposit scheme, which means they can put down as little as 2% deposit plus stamp duty. And in Victoria, if it's, say, a $700,000 purchase, that means they'd need about $50,000 in total from the settlement or otherwise to be able to purchase a property. And the stipulation is as long as they don't already hold a property at the time of settlement. So they don't have to be first home buyers. They could be somebody who's owned multiple or currently owns a property, but at the time of settlement for this purchase, they no longer do.
Okay. Yes, that makes total sense. And so is there a threshold around how much the property can be worth?
Yeah. So in different states, different thresholds. So in Victoria, it's, say, $950,000.
Great. We have an office in Sydney. How much is it in Sydney?
Well, Sydney, unsurprisingly, given that it's the most expensive market in Australia, the cap is actually $1.5 million.
Interesting. And how about in Brisbane?
Yeah, Brisbane is $1 million, more than Melbourne, but $1 million in Brisbane too.
And our firm has just acquired a practice in Adelaide. How much is it in Adelaide? Yeah,
so $900,000 for Adelaide. So they're pretty reasonable caps on that the government's willing to accept. Important to note as well that that's for capital cities or regional centres.
Yes.
So if you venture outside of that, those caps are actually lower.
That makes total sense.
Okay, so I'm going to change gears a little bit, Nat. We talked about property and breakups when it comes to finances, but we know there's a real people element involved in it, not just people from assets, as I said, and what it looks like financially. But I'm from a broken home. My mother and father separated when I was 8 years old. And there's an assumption out there that when husband and wife, for instance, as an example, when they split, that the children always would become, say, custody with the mother. And I'm assuming, is that a myth?
Absolutely, it's a myth. So working out when people separate, they often want to know what's going to happen with my kids. And it is a specific situation for every individual case. But there isn't a guarantee that just that the kids are going to go and live with their mother primarily. The court looks at what's the best interests of children. And it's in the best interests of children to have a relationship with both of their parents. That doesn't mean that it's equal, so 50-50. It could be that they spend substantial time with both of their parents. There is some presumptions around decision-making for kids, so long-term decision-making, where they go to school, what medical issues they are, making medical decisions. Those are long-term decisions. What you're going to have for breakfast, the parent who they're obviously living with can make that decision for them. You often would encourage people to have some type of relationship where they can spend substantial amounts of time with both of the parents, but there isn't a guarantee that that's what's going to take place.
Okay, so the bottom line is that when people come to either one of us, it can be very emotional. Buying a house is emotional. Breakups or family law can be emotional. So I guess knowing that you have vast experience, how many years have you been doing this for?
Over 20 years.
Over 20 years of dealing with relationships, right? So people come to you and they have all of this anxiety and uncertainty. But I think that's a really good benefit of having someone with such experience in either sphere to be able to help them navigate through the people part of what they're about to do. So we hear a lot in the media about domestic violence or partner violence rather, and I just want to know how that factors into, say, a separation.
Yes. So just recently, there's been some changes to the legislation in the Federal Circuit and Family Court regarding domestic violence. So what that means is that the court will take that into account when they're determining what a property settlement would look like for a party. It's also taken into account in making decisions regarding children arrangements and who children would live with. Because if there's been a domestic violence situation, it can really fracture the relationship between the parents and make it difficult for them to be able to make decisions regarding their children. We have what's called no-fault divorce in Australia. So what that means is that there's if one person has an affair, it doesn't mean the other person gets more money because they've had an affair. What that means is that you're looking at what people have brought into relationship, what factors what contributions they've made in the form of gifts and inheritances. You're looking at what their future needs are, what their income earning capacity is, if there's medical needs that are taken into account. That all helps you to work out what an end result will be in a family law settlement.
Okay, good to know.
If people are involved in a domestic violence situation and they need protection, you can have different forms of family violence orders. In Victoria, they're called family violence intervention order. In Queensland, they're called a domestic violence order. In New South Wales, they're called an apprehended family violence order. In Western Australia, they're called a restraining order. But we have a national system for our intervention orders. I'll use that terminology because we're in Melbourne today as we're having this conversation, but they're universal across the country. So if you commit family violence and you've got an order in place in Western Australia, you can still be charged by the police for breaching that order. An intervention order isn't a criminal conviction. People often think it is, but it's not. It's only when you breach that order can you be criminally charged by the police. Okay,
there you go. Well, so again, so many other things to navigate in relationships.
Absolutely. And they're complex. And the reality is no one enters a relationship thinking it's going to end. And so one of the things that if I could give any advice to anybody is that they really need to go and see a lawyer and make sure that they have a legally binding settlement. Unfortunately, I see so often that people think they've got an agreement with their spouse, but then something happens into the future and the person comes back and asks for more money.
Yeah.
The only way you can avoid that is to have a legally binding settlement. We have many clients that are considering separating or they've separated from their partner and they want to know, can I keep my house? When should they engage a broker?
They definitely need to speak to a broker as soon as possible when they're even considering it or before it's even become like wheels in motion.
Yes.
And that's because they need to know how much they can afford if they were to replace the property. So quite often people will go, oh, we'll just split 50-50, which I know is not the case all the time. But
Yes.
I'll split the equity and I'll go and buy another home, but they may not be in a position to buy another home. So in 15 minutes on the phone, I can work out their borrowing capacity for when that actually happens. And because I do this every single day, it's very simple for me to do. And 75% of people have brokers.
Yes.
But
Okay, and so do people need to have the actual determination of what they've got and they're getting from the settlement before they can get approval for their loan?
They don't. No, we can actually come up with like a hypothetical pre-approval as such to say that, you know, in this event, this is what you can get approved to as a maximum. Having said that, it would really help if we know some of those numbers roughly to do that. And I think I mentioned before that 75% of people use brokers. So that means 75% of your clients statistically would already have someone that could assist them. But when I say they have a broker, they may not have spoken to them for 10 years. And they also might not be a broker that can answer their questions about family law because they don't partner with a professional like you that can answer questions. So this is my domain. I do it every single day and I can really help them early on to make sure there's no dramas later on.
Great. And we often are advising our clients that they don't actually have to be divorced till they go and work out their arrangements in regards to their finances or their children. That seems to be a misconception that people have is, I've got to get divorced and then I can sort this out. Our recommendation is as soon as you separate that you should be looking at what your financial arrangements are and your arrangements for your kids, because those first crucial moments after separation can really have great influence over what happens in the future.
Yeah, and that's why they come to us first, because then we know what that will potentially look like. So the conversations with you are much easier and to the point.
Yep, that's great. And same thing from our perspective as well.
Breaking up or considering it, do they always need a family lawyer? Or, you know, a lot of people would just separate and go on with their lives.
Yes.
Do they need one?
I recommend that they do if they have any money. And in Australia, that can be having superannuation, for example. That's an asset. You might not be getting the benefit of that until you're in your 60s. But the reality is it's an asset that needs to be determined and it can be split. I think that clients often come to us with an expectation that they're organising their family law settlement is going to be like watching a television show. And they're really bitterly disappointed. It's quite often the exact opposite. Family law situations are difficult emotionally. I don't think anyone enters a relationship thinking it's going to end. And so whether it's their choice to end the relationship, it was a joint choice, or the other person's made the choice for them, it can be heartbreaking for people. I think the thing that I try to install in my clients is this isn't the end of their life. And there is actually, they have hope and a future beyond the end of their relationship, and they can have another relationship again. This doesn't mean that that disqualifies them. So if your relationship has broken up and you need some advice regarding refinancing or purchasing a property, you can contact Lee at Fidget Finance and he will be able to assist you with all your lending needs.
And if you need legal advice when it comes to family law, before, during or even after a relationship, Natalie Fielding is your gal from Macpherson Kelley.
Thank you.